Welcome, ladies and gentlemen. Thank you for being here this morning. Yesterday was a driving task for several of you, and this morning the traffic where I came from was amazing. So I don't know, it must have been a wreck, but thank you for being here. Mayor Brooks, you wanted to address this briefly before we get started?
Thank you, Chairman. I wanted to say I will be leaving a few moments early today, and I apologize for that, Mr. Chairman, but if I don't get a chance to wish you and the members of this great TACIR Commission a very Merry Christmas and Happy Holidays from me and my family, I wanted to do so before we get into the serious part of this agenda, and to say I'm honored to serve with you, Chairman. Thank you.
Thank you so much. We appreciate your service. Are we ready to go? All right. If you'll look on your agenda this morning, Public Chapter 827, Global Positioning System Monitoring Panel. This is a matter that's very near and dear to my heart, and so I'm looking forward to the information we get today on this. So if you would, Jennifer, you ready?
Yes, I'm ready.
Thank you.
Good morning. Thank you, Mr. Chairman and Commission members. My name is Jennifer Berry, and I'll be introducing the panel this morning in just a couple minutes, and I'll be turning it over to them to speak and answer your questions. But I just want to quickly remind you that we presented this draft report at the last meeting, so I will not be presenting it again today, and it's in your docket books for your reference behind tab 7. We did make a few changes to the draft since the last meeting in response to your questions and concerns, and that new text is shaded gray throughout the draft report. We will present the final report at the January meeting, and it will reflect any changes that are necessary based on today's discussion. And that final report is due to the General Assembly by February 1st, 2020. Again, just as a reminder, Public Chapter 827, Acts of 2018, directs the Commission to conduct a study of the effects and implementation of Global Positioning System, or GPS, monitoring as a condition of release for defendants accused of stalking, sexual assault, domestic abuse, and violations of orders of protection. The recommendations in the draft report remain unchanged since we presented it at the last meeting, except for one sentence that was added in response to feedback from the Commission. And that sentence is on page 7 and says, local governments that choose to implement GPS monitoring programs should work with partner agencies to clarify roles and expectations and develop and commit to procedures and policies. As requested by members, this morning you will hear from a panel of experts who have knowledge of domestic violence and pretrial GPS monitoring, and who represent different perspectives on the issue. I will introduce the 4 panelists, then each panelist will speak for 5 minutes. And after all the panelists have presented, I will have plenty of time for questions and discussion. So it would be helpful if you could save your questions till after all the panelists have had a chance to speak. Starting this morning, close to me here is Lieu Carson, Vice President of Strategic Sales with Sentinel Offender Services. Next to him is Deputy Chief Don Crow with the Memphis Police Department. Then we have Ms. Cathy Walsh, Executive Director of the Tennessee Coalition to End Domestic and Sexual Violence. And finally, Mr. Patrick Froeg, Executive Director of the Tennessee District Public Defenders Conference. And thank you to all the panels for being here this morning. I'm going to ask Chief Crow to speak first to describe the Memphis pilot program. And he has a PowerPoint, and also Mr. Carson has a PowerPoint, and those slides are in your docket book. And with that, I will turn it over to Chief Crow. Thank you.
All right, Chief, welcome. Thank you for being here today.
Thank you, Chairman, other Commission members. I am Deputy Chief Don Crow from the Memphis Police Department, and I do bring greetings from the western edge of the state of Tennessee. It was a beautiful drive up here this morning watching the sunrise in this great state of Tennessee. I'd like to talk about our GPS program that we've had in Memphis, and I'd start with the goal of the program. The goal was to enhance the safety of aggravated assault DV victims, and it was through the enhanced monitoring of suspects on pre-trial release. So all the devices were attached to suspects that had been arrested, they had posted their bond and got out, but their case had not been adjudicated. Once a case had been adjudicated, then the device was removed. The partnering agencies that participated in this with us. It was never a Memphis Police Department project. It was a cooperative effort from the Memphis Police Department, the Shelby County Sheriff's Department, the Shelby County District Attorney General's Office, our Family Safety Center, Shelby County Pretrial Services, and the University of Memphis. We started our program with grant funding July 5th, 2016, and we attached GPS devices to any suspect charged with aggravated assault, DV, or an attempt murder, DV. As you all know, bail conditions never set an exact distance that the offender is to stay away from the victim. Bail conditions advise that the suspect should have no contact with the victim and should stay away from the victim's residence or anywhere that the victim is likely to be. So part of this program, our working group, put together buffer zones and exclusion zones. And this is an electronic geofence built around the address that the victim chooses. So it can be the victim's home address, the victim's mother's address, the victim's work. If the victim's in school, the victim's school. We build the buffer zone large, and then anytime the offender crosses that electronic geofence, a buffer zone alert is triggered, and then our officers with the Memphis Police Department Real-Time Crime Center begin monitoring that event. The buffer zone usually did not trigger an investigation, nor did it trigger a response. It was just a way for us to know that the offender was getting close to the victim and we should pay attention. Much smaller than the buffer zone is the exclusion zone, and when an offender entered an exclusion zone, we do trigger an investigation. That investigation includes calling the victim to tell the victim that the offender is near, and the victim should take a safety plan and start activating her safety plan, and then the Real-Time Crime Center notifies uniformed patrol officers to respond to the scene. During our program, we had 2,437 offenders get released with the GPS devices, and we also offered every one of the victims their own device, which allows the mobile geofence to go with the victim wherever she goes or he goes. So if you think of it in terms of this, we build the geofence around the victim's house, but if the victim is at a convenience store, a grocery store, or a shopping center, there's no fence there protecting the victim. But if the victim chooses a mobile device, that fence, the exclusion zone, the buffer zone, moves with the victim. Out of the 2,437 offenders that got the device, we arrested 510 of them for violating their bail conditions. Of the 510 that violated their bail conditions, 266 were charged because they violated the exclusion zone and got too close to the victim. The other violations included 39 offenders that actually cut their device, threw it away, and absconded. The rest of the violations were people that refused to comply with orders of charging their device and keeping their device active. University of Memphis has been a partner in this since the very beginning, and they've provided some recommendations for managing the program. Certainly we'll provide everyone with a copy of these. At this point, I'd like to maybe highlight the last two. And it says, whichever agency assumes primary responsibility for the administration and management of the program should hire a program manager to manage the daily operations, streamline some of the processes, especially as it has to do with inventory and distribution of the device. And law enforcement should not be administering and managing the program, but should be a critical partner with responsibility for real-time monitoring and response to violations. Additional recommendations from the University of Memphis is focus on intimate partner domestic violence. Our program focused on all domestic violence, so if it was blood relatives instead of intimate partners, they were participants in the program. And again, include intimidation and stalking, recommending GPS in lieu of bond conditions. Our program was in addition to bond. And then violations of bail conditions, violations of the GPS program should have very serious consequences. Currently, if they were arrested, violation of bail conditions is a maximum of 10-day sentence. So we saw several times where they would be arrested, they would serve 2 to 3 days for violating the bail conditions, and then they would go right back out on bond for the active aggravated assault case. With that, I'm going to turn it over to other people. I look forward to answering questions that you might have.
Thank you. Who's next? Mr. Lee? Go ahead.
The presentation up for you. I have nothing to add. Chief Crow's taken all my thunder. He's done a fantastic job, as always. I'm Leo Carson, the Vice President of Strategic Sales with Sentinel Offender Services. In my allotted time, first and foremost, I should say thank you for the opportunity to participate in your meeting today. In the allotted time for my presentation, I'm going to address several items. First and foremost, to tell you who Sentinel is briefly and our background. Tell you a little bit about the current technology that's out there in the industry currently. In 2020, Sentinel will be delivering a number of advanced technologies that will become available this next year. I'll tell you about some of those, and last but not least, I was requested to provide information on the cost of the program and the devices. I'll be addressing factors that attribute to that. Sentinel was established in 1993 and has remained under the same ownership for that period of time. Our management team, made up of about 6 key members, myself being one of them, has over 160 years experience directly in electronic monitoring. Sentinel is an original equipment developer, manufacturer, and one of the world's largest providers of monitoring services for community corrections, including, but not limited to, specialized programs for domestic violence applications that include, as an example, we are the incumbent contractor since the inception of the program to Memphis PD, also to Cook County, Chicago, Illinois, and also statewide for the Connecticut Judicial Branch. A little bit about the current technology which is available. A tamper alert bracelet is worn on the ankle of the perpetrator, which uses GPS satellite signals to determine location and cellular signals to report that information to a 24-hour monitoring center. The battery life of the current technology, that's on a single charge, is approximately 24 to 72 hours, which would require the perpetrators and the victims once per day for 1.5 hours to connect the charging cable, like you see on the far right in the image. They would connect that from the face of their GPS tracking device to the wall outlet for approximately 1.5 hours a day to keep the device fully functional, fully charged at all times. The system works and delivers data through a secure web-based system that, as Chief Crow was pointing out, enables officers to establish zones and associated schedules to track perpetrator compliance. Those include, as the Chief had mentioned, inclusion zones where perpetrators are required to stay within, exclusion zones around victim locations where the perpetrators are required to stay out of, and in addition to that, buffer zones that Chief Crow had pointed out are a perimeter around the exclusion zone. And the purpose of that buffer is, before a court-ordered zone is permeated, that buffer zone provides the capability to have advanced notification by the monitoring center staff or by officers to solicit compliance, separation in line with the court-ordered distances. Now, it's important to recognize that those 3 zones, as Chief Crow pointed out, are stationary. So industry-wide, with all the companies that do what we do, there's a limitation in the fact that that leaves gaps in coverage at times when we use her for the purposes of describing the victim, at times when she's mobile in between those zones, that can provide gaps of coverage where there would be no notification. So a unique factor that Sentinel's technology did, again, as Chief Crow pointed out, is the ability to have the option of having the victim have her own GPS tracking device in addition to the one on the perpetrator's ankle. This would be one like you see in the center of the screen that she would hand carry, charge, keep with her smartphone, her purse, her car keys, to take with her wherever she goes throughout the community. Now, this unique option provides the added capability of providing a mobile victim zone around that device that would go with her throughout the community. So as an example, if the perpetrator and the victim both dawned a Walmart on Sunday afternoon, with innocent intent and lack of knowledge, this would provide that coverage and advance notification to allow intervention to occur at an arbitrary location because of that mobile victim zone. Those are the capabilities of the current technologies. As I pointed out, in 2020, Sentinel will be releasing some advanced technologies that will be engineered and manufactured directly by our company. That includes a GPS device that you see on the right-hand side versus the one on the left-hand side, which is the current one, a device which is 40% smaller and lighter for the perpetrator to wear. Battery life on the current device, as I pointed out, is anywhere from 24 to 72 hours on a single charge. That will be now 2 to 3 times as long, leapfrogging to be 8 to 16 days on a single charge, so requiring much less intervention on a perpetrator or a victim to keep the device charged. More specifically, charging itself will happen without having to cable the device or the perpetrator cabling their leg to the wall using a cable. There will be a portable power pack like you see in the photo on the bottom, which will eliminate that charging cable and allow either the perpetrator or the victim to remain mobile even during charging. The technology used to communicate the information to the monitoring center will get significantly more agile and diverse, meaning that any single device will have the capability to automatically detect the cellular provider that's strongest in a given area. As an example, if the perpetrator works in a location where AT&T is the strongest cellular coverage, but yet lives in an area where Verizon is a better coverage, the device is agile and intelligent enough that will automatically adapt to the cellular provider that's strongest as they move throughout their day to different locations. Onboard communications will be available inside the device. This will give the officer the ability to have the device provide spoken instructions verbally from the device itself, in addition to a beep tone, a vibration, or a siren, a 90 decibel siren in extreme cases where if there is a pursuit underway by supervising agencies, they'll have the ability to activate that siren in addition to GPS mapping of it. Last but not least, the device will become more accurate for tracking. The current technology is dependent upon GPS signals from the satellites in orbit or cellular signals from the ground-based cellular network to do tracking and reporting. In the absence of those two, for participants that end up in locations where those two are both weak, the new device will have a 9-axis motion sensor to determine motion and detect and plot points for tracking based upon those 9-axis motion sensors. So in the absence of both signals, it will still be able to determine tracking and plot locations. Last but not least, we talked about the option of a victim device that's currently hand-carried by the victim as an option. We will replace that device with an application that can be downloaded onto her own personal smartphone. This application will use the internal GPS tracking capabilities embedded within all the smartphones that we all use to track location and attribute it and monitor and compare it to the perpetrator's location. This will also provide her several features which you see across the center bottom of the screen, including the ability to configure which alerts, which non-compliant activities of the perpetrator prompt her with alerts through her smartphone. At times, and if the zone, her buffer zone and or exclusion zone or mobile exclusion zone are breached, at that time it will also provide her the capability to detect and view mapping location of the perpetrator with perspective to where her location is as well. That will allow her, obviously, to activate her safety plan at that point in time. In addition to that, it provides her single-touch, one-touch capability to dial 911 for emergency services as well. So this will replace the need for her to carry and charge her own GPS device, rather using an application that would be monitored on her own smartphone. Several factors attribute into the cost for GPS tracking for these types of programs. That determines on whether the services are being provided by the government contractor, staff, or monitoring center, or by the government agency staff and monitoring center. Some of those services I'm speaking about are the installation of the equipment, the maintenance of the equipment, the removal of the equipment from the perpetrator, orientation of the perpetrator on how to interact with the equipment. Monitoring services and triage alert is also a service that would be determined based upon who's providing it, as well as fee collection. Other factors are whether the technologies and services are being provided only for the perpetrator or for both the perpetrator and the victim. Whether the services are offender paid or government agency paid, and many of these programs require the perpetrator to pay for not only their own device, but the optional victim device. So that would be a determining factor. All of those factors considered, those points made, it's approximately $4 per unit per day, anywhere from there up to about $10 per unit per day, depending upon who's providing those services and depending upon those factors. I want to thank you again for allowing me to participate, and I welcome any questions that you may have.
All right, thank you so much, Mr. Carson. Who's next? Cathy, Ms. Walsh, you want to address this next?
Yes.
Thank you.
Good morning. Cathy Walsh, Director of the Tennessee Coalition to End Domestic and Sexual Violence, and we are the state coalition of battered women's shelters, rape crisis centers, and other types of programs and agencies who are working to end violence in Tennessee. So I do want to, I just have a few brief remarks. One is I really appreciate you and members of the General Assembly looking into this issue. As we know, it is a serious problem in Tennessee. Currently, we rank 5th in the nation for the number of women who are killed every year by their husbands or boyfriends. And unfortunately, for the past 2 decades, we have been somewhere in that top 10. We've been as high as number 3 and as low as number 9. So it does behoove us to look at all types of things that we can do to try and protect victims. I do agree if there's going to be a monitoring system that it has to be an active system, that it is being monitored 24/7, or it's not going to be really helpful for victims. So I think that's really important. I also think that it's critical to understand that GPS monitoring of offenders is only effective if it's part of a larger coordinated community response. As Memphis was talking about, that you have all the players involved, that there's training involved for everybody in that system. And if not enough trained officers can quickly respond when an offender approaches a victim, and if a court lacks the resources to hold offenders accountable, the monitoring devices will be ineffective. It is vital that community-based advocate also explains to the victim how the offender tracking system works and what its benefits are. If the community offers real-time tracking of victims, it's important to note that while this additional service may offer the victim extra protection, the victim who has not committed a crime is tracked 24 hours a day. This can raise serious safety and privacy risks for the victims. It creates a risk that the offender or the offender's attorney may try to obtain the victim's location records in an effort to intimidate or harass the victim further by the perpetrator, not the attorney. I just want to point that out. For safety, a monitoring agency's policy should restrict access of the victim's location to the fewest staff possible, so who has that information. And any victim who is considering carrying a GPS device must be fully informed of all the risks and benefits, provide consent before being tracked, and must be able to withdraw that consent at any time. The monitoring agency should be working with a nonprofit advocacy program like a domestic violence shelter to safety plan with the victim. The victim's location, if it's being tracked, there should be policies around how, what's going to happen to that information once it's obtained, who's going to have access to the victim's location and the records and so on. I do believe that GPS monitoring, if we're going to do it, should be part of the bail conditions, because there are certainly other conditions in the bail conditions that would need to apply. I believe that if you're going to have a system, that it shouldn't be limited to intimate partner only, because we know domestic abuse also includes relatives. Recently, I worked with a victim, an adult victim whose father had been in jail, got out of jail, was stalking her, raped her. So it's not, and she would not consider her father to be an intimate partner. And if you're a rape victim, you don't consider them to be an intimate partner. So I think instead, what categories of perpetrators that we look at who might go under GPS monitoring should be based on factors and a lethality assessment for that perpetrator. I think that the perpetrator should pay for the tracking devices as part of holding them accountable. I don't believe that any funds from victim services should be used to pay for indigent defendants, because in Tennessee, in terms of state money that we have available for domestic violence programs, it's only around $1 million a year. So think about that. For sexual assault programs, there's a little fine money, and I understand last year it was about $70,000 a year. So we have very limited funds for victim services. I would hate to see any of that money be taken to be used for tracking. And, our concerns are to the cost. So I know others share those concerns, how would the cost be taken care of, and what sort of burden would that put on the law enforcement agency, the community, the courts, and so on. So I know you'll be looking into that as well. So thank you very much.
Thank you, Ms. Walsh. Patrick, you ready?
Yeah, hi, Patrick Frogue. I'm the Executive Director of the Tennessee District Public Defenders Conference. When the research staff reached out to me, I shared just some sort of initial concerns, and then I think we had multiple conversations where I shared a few more. All of those are included in the draft report that I've seen. I don't think I've seen the very latest, but I think they did a good job of including everything I said. I'll make a few points really quickly. In general, when electronic monitoring is used in lieu of pretrial incarceration, and that may or may not be where this ends up, but when used in lieu of it, it's exciting to me for a couple of reasons. One, people are out pretrial before they go to court, and second, those people who stay out, it's a caseload control for us. They tend to keep their jobs, work, hire their own lawyers. Whereas we get a much larger, at the Public Defenders Conference, we get a much larger percentage of people who are in. So when used in lieu of incarceration, I think it's an exciting possibility because it would also help with the local pretrial incarceration, which, as you all probably know, is high. But the points I made were, number one, for folks who aren't lawyers who practice in domestic violence, the definition of domestic violence in Tennessee is very broad. And so it includes not just intimate partner violence, what Ms. Walsh was just talking about, but family members, roommates, former family members and roommates. Lots of people get swept up in this, and I think what Chief Crow was talking about, they tried really hard in Memphis to limit it to the folks they were targeting. The most dangerous, from his perspective, folks are probably intimate partner violence. That's your judgment, but I just wanted to point out the breadth of the statute because I think it's a concern. Two, all the clients that I deal with are poor. At the Public Defenders Conference, we represent indigent clients. I think the draft TACIR report noted that the Administrative Office of the Courts estimated that's about 75% of people charged with a crime. So this has a potential to be a vast program. If you were to mandate, for example, GPS monitoring on every domestic violence offender, the state could be on the hook for a large percentage of that cost, whether you want to or not, whether you intend to waive it. The reality is, particularly in large urban jurisdictions where there's just a huge caseload, my experience at least is that those court costs end up being borne by the state, whether they're initially charged to the individual or not. So I think the program could be costly. On the other hand, if you're saving a lawyer and you're saving pretrial incarceration, that might offset that. But that's sort of above my pay grade. And finally, the last point I made was when they talked to me about the lethality assessment, any lethality assessment that intends to narrow the pool of people who qualify, if the one that I was informed about was based solely on questions asked of the victim at the time of arrest. And I certainly understand that that's going to be a key component of any lethality assessment, the alleged facts of the case. But I think any overall assessment that's systematized would have to hopefully be based on more objective criteria. And those could be any number of things. I actually think Memphis may have recommended that coming out, but I'm not sure. So those are the points that I made, and like I said, I think they are included in the report. Thank you.
Okay, all right. Chairman Crawford, you're recognized.
Yes, I want to go back to the gentleman here on we were talking about. You said something about they would be able to download an app on their phone, and that would allow them to make a statement and also to have one individual device that they could use, victim could use as far as making up their surrounding area. Would there be a cost to the victims for that? And would it be covered under insurance? I know most apps are very inexpensive, but still yet, for something that technical and has to be exact, I'm just curious, would there be a cost to that?
We're not looking at cost for the victim application. It would be integrated within the cost range that I gave you between $4 and $10 a participant a day. So there would be no direct cost for the application once it's available.
Okay, and the zones that you were talking about, if there is no Wi-Fi connection or anything in those particular areas, would that work off of satellite? Would there be dead spots to where these individuals could possibly get in that there wouldn't be any coverage? Or these are guaranteed to be covered no matter where they're at?
The current technology which is available uses either GPS satellite signals, which come from the government satellites in orbit, or cellular signals to track the location and report the information. So the capability to monitor those zones is predicated on the current technology by the availability of both those service signals. On the new technology that's coming out this next year, that device will have the ability, in the absence of those technologies, to use the zones which are stored on board the device to calculate location at times when cellular and GPS are both absent. So that will be a capability of the advanced technology coming out this coming year.
Okay, so you feel pretty comfortable then that there wouldn't really be, if there was any dead spots, there wouldn't be any, not many if so. That's something that y'all would continue to work on.
That's correct. That's one of the reasons we put together the advanced technologies. You have other companies in the industry which have targeted the use of Wi-Fi, which you mentioned, which we believe is a benefit to have it, but it's not as big a benefit as the 9-axis motion sensor, because Wi-Fi, as you may know, are stationary locations that are spotty. Some locations have them, some don't. So we believe that's a weakness in having one other external signal that could be received or not received that would predicate the ability to determine location. The 9-axis motion sensor doesn't require any external receipt of a signal and would be in place in the absence of cellular, GPS, or Wi-Fi.
Thank you, Mr. Chairman. If you can indulge me one more question.
Certainly.
If this goes into effect, and let's say we have victims who download this on their phone or their portable device, whatever that may be, and there is an instance where there's a violation that takes place within the area that's excluded, is there someone there that's monitoring this 24/7, or would this just put off an email to someone, hey, this has been violated, you need to check this out, send the police department, or would there actually be a physical person monitoring each one of these in say, a 911 center?
The answer to your question, sir, is yes. First and foremost, the app would provide her additional information, but that is not the only means by which the victim and/or the perpetrator are contacted. What's commensurate in these programs, and varies agency by agency, is that a monitoring operator, be it someone that works for my company out of our 24/7 monitoring center, or at the agency's own monitoring center, if they're staffing it, would receive the alert when the buffer zone is breached. Again, that's an outer perimeter that's much larger than the core specified court-ordered zone. And the purpose of that buffer is to do exactly what you're asking about, for some live operator to take that alert, usually through a set of recorded telephone lines, and it may be two operators doing it, one contacting the perpetrator, one contacting the victim, soliciting separation from that location, notifying them verbally on that recorded line that they've breached a buffer zone. You need their prompt response, asking for acknowledgement. Do you understand the instructions you've been provided? This notification is being provided to you in advance of the court-ordered zone being breached. Do you understand these requirements? Please comply. And monitoring on the screen whether they comply or not with that separation at that point in time. So the answer to your question is the app would be an automated ability for her to see the zone, receive text alerts or email alerts, in addition to a live operator usually making contact with both the perpetrator and the victim.
Okay, and you brought something up there that just kind of brought something else to my memory. If we have the technology to do this, then could we not also apply this to sexual predators and stuff, that we could put a buffer zone around school areas, around kids' areas, that if this individual who's a registered sex offender or whatever was to get within one of those buffer zones of a school or something like that, that it could also work in that instance to make us aware of that.
Absolutely, it can. And more specifically, you can do it for judges, witnesses, victims, as we're discussing here today. You could also do it for multiple of those type of individuals for any single perpetrator or offender. So you can configure that independently from multiple contacts.
Thank you, sir. Thank you, Mr. Chairman.
Welcome.
Thank you. Mayor Bickers.
Thank you, Mr. Chairman. I've got a few questions. And as I acknowledged at our last meeting, I come to this with perhaps a different point of view. For several years, I chose to fulfill my pro bono requirements by representing women in women's shelters who were often there because of domestic violence. And Chief, so I've got some questions and concerns as to why we would choose to alleviate jail conditions or other problems by targeting alleged offenders of domestic assault for release versus perhaps other classifications of people that are incarcerated pre-trial. Chief, you mentioned that 510 offenders in the program out of about 2,400, about 20% of those were arrested as offending. How many, you've got how many arrests there were, how many repeat assaults occurred where someone was assaulted by the person who was let out?
Yes, sir. The University of Memphis in their study put all that in there, and I'm sorry I don't have those numbers fresh in my mind, but it was relatively low. But there was some offenders that, despite the GPS program, they did go to the victim's house and assault the victim before we could get there. And we had one or two instances where the victim agreed to meet the offender outside the zone. One that comes to my mind is the victim met the offender at a hotel, and then once at the hotel, the offender did assault the victim. But again, it was outside of any kind of exclusion zone.
Okay.
That was relatively small.
And my experience has been, again, it's my personal experience, is that when particularly men are arrested for domestic assault, it's usually when they're high or they're drunk and they get sober and they beg and they plead, let me out, I won't do it again, and then they get high and drunk and repeat the offense and beat their wife or their children. So I think that's important, that we make sure how we identify who we would allow to utilize this program. How does Shelby County decide who is appropriate versus who's not appropriate to have this form of pretrial release?
So for the purpose of this study, and our GPS program was a study that was funded by OCJP here for the state of Tennessee. We included all domestic violence offenders charged with aggravated assault or attempt murder DV. And we did, in the beginning, try to keep a scoring sheet that included a lethality assessment, also a sheet by our pretrial services to score them, and we set a threshold based upon a complicated scoring formula of 23 to see if people that scored above 23 were more likely to violate bail conditions than people below 23. It did not, but in the University of Memphis's final recommendations, they do say that we should come up with a lethality assessment, some way of ranking offenders based upon their likelihood to offend again.
And who performs that assessment in Shelby County?
Well, the scoring sheet, the lethality assessment that we use is the Maryland lethality assessment. It's completed by the uniform patrol officer while he's on the scene with the victim taking the offense report. And then it's forwarded to our Family Safety Center, our domestic violence unit for future, and the general District Attorney General's office for future use.
So it's the officer at the scene who would basically do the scoring under that Maryland assessment test. Did I understand that right?
Yes, sir.
Okay. At what point in the process is there an advocate for the abuse victim?
So certainly the next day, the victim, and we go on the assumption most are occurring after normal hours. the victim is referred to the Family Safety Center for an advocate. But then based upon our lethality assessment program, if it scored a high risk from the scene, the uniform patrol officer calls an advocate 24 hours a day, hands the phone to the victim, and then that advocate starts offering services right there on the scene. That includes transportation to a place of safety, emergency shelter, and things of that nature.
And so it sounds like Shelby County has victim advocates that are available to be engaged in this process fairly early.
Yes, sir.
Do you believe that having that victim advocate would be a significant, important part of any program that the state would adopt in this?
Absolutely, yes, sir.
One of the areas where we see a lot of involvement with trying to put together any type of restraint on behavior is with orders of protection. There are hundreds, if not thousands, of orders of protection reviewed and entered this every week in this state. Does Shelby County utilize this when an order of protection has been entered by the court for whatever reason, pretrial, for whatever reason, even in a civil case, that says the individual is restrained from going about the person who has successfully obtained that order of protection, or is it just in the criminal context?
So for purposes of this 3-year study, it was just people charged criminally. It did not correspond with orders of protection. But again, the University of Memphis addresses that in their study and their recommendations, and they do include order of protections.
And I noticed, and I'm not sure who would be appropriate, that as we currently have funding at the state level, but how much of that, I know a lot of it goes to ignition interlock devices where, I believe in my county, Blount County, that's where the money's being used. If you are out and you've got a drunk driving arrest, you have to have that alcohol protection on the ignition interlock as a condition of your release. Is there any state funding currently that's being used other than what we see in Shelby County for this type of program? To provide it to indigents, or I'm just curious as to how much we're doing today.
Jennifer?
Yes, the Electronic Monitoring Indigency Fund is available now as of this year to fund GPS monitoring in this context. The amount is, I don't know how much is available for GPS monitoring for domestic violence. The Ignition Interlock program is the priority in that fund, so that Ignition Interlock is 100% state funded, and then excess funds go into the account for other alcohol monitoring and GPS monitoring. And as you know, there's now a 50% match, so counties that want to participate submit their budget and commit to a certain dollar amount, and the state matches that amount. And they're, in your draft report, we added information about the counties that are currently participating.
Okay. But I didn't see that you broke it out by, I saw that, for example, Blount County is getting $50,000. I believe that's mostly for ignition interlock devices. Do we know how much is being spent on monitoring, of ankle monitoring, as I will call it, as we're discussing here?
I believe that the amounts that we have in the draft report are not for Ignition Interlock, because Ignition Interlock is 100% funded by the state. So those amounts that the counties are have committed are for other types of alcohol monitoring and GPS.
Okay. And I've got one more question, and lots of times the women I've represented were in a shelter, and there was great effort made not to disclose their location, not necessarily because of the individual that had perpetrated violence on them, but concerned that there may be family members or other, if they know where they are, who are upset that he's in jail or would show up. And under this system, would those women have to agree to give up their location so that the victim and or whoever would know where they are, so that the offender knew not to go there. So what steps do we have to protect the women who need to have their location kept secret? Do we tell them, do we just say in those instances, nobody gets this device? How do we deal with that situation as we look at this program going forward, or as how it's being handled in Shelby County? I'm just curious.
Absolutely, sir, and I would like to address that. So bail conditions set in Shelby County never give the offender an exact address to stay away from. At no point during their training, during the instructional program, are they told to stay away from this exact address. Bail conditions say no contact with the victim and do not go anywhere near the victim's residence or anywhere she's likely to be. So we have our domestic violence investigators contact the victim after the suspect is released from jail, whether that's a 24-hour period, or in some cases it could be a week to 10 days before they're able to post bond and get out of jail. Our investigator calls the victim and says, your offender was just released from jail. He is wearing a GPS device, and we would like to build a geo-fence around any address that you would like protected. And then we get that from the victim. If the victim does not want to tell us where she's going to be at, then the offender's out there, but there is no GPS fence built around an address.
Right, there's really no reason to put that, unless you have an address to have them avoid. There's really no reason for the ankle monitor, is there? Because there's no place put in there for it to go off if they violate it.
Sir, we would think there is, because it still shows us where he's going, and it can show us if he's going to places where she's at or places where she's likely to be. It leaves a breadcrumb trail of his location.
All right, that makes sense. Thank you, Mr. Chairman.
Thank you. Next, Senator Yarborough.
Thank you, Mr. Chairman. So how precise are the exclusion and buffer zones? And I mean, I guess what I'm thinking about is how do you deal with a situation where perpetrator and or defendant and victim live in the same area? Is there a way to sort of draw that well? And then I'm trying to think, did any complications arise? Because I guess you could have situations where two parties to a case work in the same building, work somewhere similarly. And I'm curious if there's how you deal with situations where there might be, an argument to be had about what the exclusion and buffer zones should be.
Sure. So it's always been an educational process, and our investigators have gotten better as more involved in the program. But we did see several times that victims would live near major streets, even the interstate, and then the exclusion zone or the buffer zone would include these major streets or the interstate. And when that alert is triggered, our investigator from the Real-Time Crime Center starts watching the offenders on a map. And so if the offender stays on the interstate at 65 miles an hour and never leaves the interstate, then it's obvious the offender had no intentions of interacting with the victim, just an overlap of it. And so a lot of times we did see them living in the same neighborhoods, but the investigator at the Real-Time Crime Center not only can see the offender's location, but offender's speed. So if the offender never slowed down, the offender never made an exact approach to the victim's location, then once he made it home, we took no further action. But the offender drove straight in front of the victim's house, and when he got in front of the victim's house, slowed down to 1 or 2 miles an hour or came to a stop. All that information is readily available in the software, and that's when the investigators would trigger an investigation.
And here's a question that I think we always have to keep in mind in the current world of data is who owns the data? How long does it stay in, sort of in a system? What purposes can it be used for? Or is it solely used in a safety capacity? Is it also like investigative data? I'm just sort of curious what constraints and rules are put around on the data.
So all the data is kept in a software program that Sentinel created, and Sentinel keeps all that data in the program. We have used the GPS data to solve other crimes. One of the very first ones that we solved was a robbery. And in this particular case, 3 victims were robbed. There was a shooting. No one was shot. And when the investigators developed a potential suspect's name, during the investigation into that suspect's background, it realized he was out on bail conditions, and he contacted our GPS program. Our GPS program coordinator was able to pull that offender up on that day and show exactly where he was at the time of the robbery, and it did put him on the scene of the robbery. So that's a side benefit to it that you can see when these offenders are involved in other crimes.
And and does that access sort of, is it perpetual? I mean, so let's say that, a victim, or, a case actually goes to trial, there's either a conviction or acquittal, and it's over. And then, and then you're investigating a crime 6 months later. Can you still go back and use that data?
Yes, sir. Now, I'd have to refer to Mr. Carson as to how long that data is stored in their software, but
It's archived to the heart of a couple of your points. The data and the information is archived by our company, and it's archived indefinitely. We have it from the first devices we ever put on when we began this level of technology. We look at the data as belonging to the individual government entity. In case of Memphis PD, that's their data. It belongs to them. We could export it in a separate file. It's accessible to them online. Depending upon the age of the event that they want to go back to, we can remove it from the archive and make it fresh in the system again as well. But to answer your question on 2 points, it belongs to the end user customer, and it's been archived indefinitely. It's very rare, but under the case of a subpoena, our company's policy with government entities is that we provide them notification. We can't deny a subpoena, but we provide advance notification to the government entity to try to file an injunction if they see fit to do so. So those are the policies that we usually have in place with our end user agencies.
Other questions, Senator?
Well, and I guess one more is, does the person who's wearing the bracelet, do they have the ability to access it as well?
They do not. They do not. Only in the case of the victim app, which we're describing, I should go back and say 2 things. There is verbal contact made by the monitoring center. In Memphis PD's case, it's one that they're staffing. For the other agencies I mentioned on our slide presentation, they pay us a higher fee to have our company triage the alerts. So they would be contacted by an operator, but normally it is never to provide the location of the victim or the perpetrator, only to solicit separation in a direction and to warn them that they're about to breach the court-ordered zone and to ask their understanding of what the instructions are that have been provided. That's all done on a recorded phone line that could be exported to a WAV file. That's an audio file that's easily emailed to a government agency or a judge if they care to hear the audio interaction, as well as a part of the looking at the mapping as well. But yes, that's correct. But no, those locations are not accessible. The only time that a victim or a perpetrator would be able to see location, as I pointed out with a new app that's coming out this next year, she'll be able to see his location with proximity to her, but only at times when the buffer zone has been breached. She cannot otherwise track his location.
Okay. And then, Mr. Pro, help me understand a little bit more where the, help me understand how the indigency determination will play into this, and how, I'm trying to think through the mechanics of how we actually will do this and pay for it.
Yeah, I think, well, I'm not sure I'm an expert on that, but I can tell you that the indigency determination is made at the court level, typically with a hearing or where a judge inquires, there's an affidavit filled out. I know in my personal experience in the trial courts, there were some of these fees that weren't waivable. So, for example, there might be, a client that is on electronic monitoring or some sort of breathalyzer device or something like that, and for some reason or another, whether it was statute or local custom, those clients had to pay that. But my point earlier was whether they were required to pay it or not, actual payment was pretty rare. The costs quoted by Sentinel today were lower than my experience is. I think $10 a day would be lower than I've ever seen a company charge for GPS monitoring, but that may be a product of where I practiced in Davidson County. So on the back end, how those costs are allocated, I'm not the expert on that.
What's not uncommon in a lot of the programs that are offender-funded is to apply what's commonly referred to as a sliding fee scale. So it looks at the income, if there is any, the household income or the participant's income on an hourly basis as an example, and apply that as their charge per day to be in the program. That way it's a pay based upon basis of earnings where it's available.
All right, Mayor McDonald, I think you have a special guest you'd like to recognize relevant to this.
When we started discussing this on the Crime Commission in Shelby County, we had a prior study to this one that was done by the University of Memphis, and Angela Madden is in the audience. I just wave at us. She was able to dumb it down so even I can understand what she was talking about, and you know, a lot of the decisions that were made at the Crime Commission level, including how some of that would be tracked, go to her information. So when you look at this page, I believe on the slide that Laura Crow's husband presented to us, she's my eye doctor, his wife, but I believe that slide is information that Angela put together. Is that right?
Yes, Mayor McDonald, that's correct, sir.
Okay. So I would just point that out that, you know, she's here if you have specific questions, because they made some specific recommendations that were a little different than what was being done in the test after looking at the information. And so I think that would, for some of us, that would be a good learning opportunity for her to explain that. I'm not putting you on the spot today. I'm just saying I want the other members to know that you're available to answer questions to them specifically about that. Thank you for being here.
Thank you, Mayor, and I hope you will make yourself available. Representative Hardaway and I are trying to draft a bill now, and that's why we came here first, to try and get some good guidance. So we would appreciate any assistance you could give us in addition to all the panel members today and the presentations they've made. Other questions or comments?
Yes.
I'm sorry. Go ahead. Yes, sir.
Yes. Deputy Chief, do you have any thoughts on whether you prefer the contractor monitoring versus the governmental entity monitoring the service?
So we purposely, for the purpose of the study, went with the lowest cost we could with Sentinel, and that has been very labor intensive. It's been very labor intensive for the Memphis Police Department. It's also been very labor intensive for pretrial services. So offenders in Shelby County are released 24 hours a day. So that means 24 hours a day someone has to be at the jail, available to attach the device and conduct the training for the offender. And then when you're talking about managing the devices, we had to convert a whole office into almost a warehouse, because you have to keep devices, you have to keep the charging cords, you have to keep the actual ankle strap in inventory, and we learned to predict that summertime and holidays there would be an increase, and so we needed to increase our inventory as those days approached. But yes, very labor intensive, and the cities that have the service provided by the company have less stress.
Because I wasn't for sure if it was government agency, if it was dispatch or those types of folks that would be monitoring it, or sole responsibility with another department within the department that would be monitoring.
So for our program, it's monitored by two entities, the Memphis Police Department Real-Time Crime Center, which is staffed 24 hours a day, and we're available and able to dispatch officers from there. But then we strictly dealt with the victim. Pretrial services monitored the offender. So as Mr. Carson talked about, calling the offender saying, You know, you need to recharge, your battery's dead, you haven't charged it. Pretrial services assume that responsibility.
And then one last thing I'm just going to mention, just because I don't know, I know that during the prosecution, there would be some prohibitions to someone receiving that data, but after the prosecution, if it is property of the government, then it could be subject to open records. So it may be something we'd want to deal with if we do have a law. If we do implement this even further, that could be subject to open records, and we might want to make it confidential if that's the intent of that, for later purposes.
All right, other questions? Thank you, and each of you. This has been a real burden on me for years, having served on the bench and tried to make these decisions. Some of the most difficult I ever made. Representative Hardaway heard me say that one day and came to me. He had a young lady in Memphis whose, I'm not sure, domestic partner or husband, I don't remember which, but she had just literally gone through the most hellish experience in the world. And so back when we were across the street, he and I agreed that someday we would do our very best to try and correct this through GPS monitoring. We've been at it ever since and haven't made a whole lot of progress, but we're going to throw the first dart at the board this year. In doing that, I've talked to both defense attorneys, district attorneys, a lot of judges. Had a meeting last week with 5 judges about this, and I find their comments to be very interesting. Number one, they were concerned that we're losing the battle on domestic violence, not winning it, which when I was there, it was of an utmost priority. They said that the primary problem is they had no proof on allegations of violations of conditions of bond was their primary concern. Our bill is going to be directed toward the offender paying or the accused paying this, and it is in lieu of bond. So the money that would be spent on bond would be spent on the bracelet. On the cost that I've talked to about 5 companies about this. My cost have been about $6 to $11, so it's pretty close to what you said, sir, and I appreciate that. I was a little surprised. The other thing that's been unanimous is that the information of the victim cannot be disclosed to anyone under any circumstances. Most of the judges want it available only by subpoena and then by production only to that judge in camera, meaning no one gets to see it unless there is a charge brought. And I had one judge that had some really great comments about this, that we, one of the people I'd contacted about a cause talked about how we can watch both the man and the woman, or the offender and the victim, and that just seemed pretty scary to me, because if the offender knows where the victim is, then we're going to make him or her, that victim, just a second victim through the process of this program, and nothing could be further from our intention than doing that. So the public records was one of the first things that got brought up last week in our meeting, and certainly we considered that. So there are a lot of hurdles to cross. I want to leave each of you, and all of you have done a great job in this and very bright. My concern is that if we try to build a perfect system out of the gate, we will never have the money to accomplish it. What I want, and what I think the majority of judges want, is they want proof of who's done what, and then they will deal with it. And so I was very interested in how, I'm not sure we've made much progress in the 9 or 10 years since I've been gone. I think maybe we've gone at least with that group, and I don't want to single them out, but they're not too excited about the project or the projected scope of domestic violence, but they were extremely excited about this possibility, because everyone has money for a bondsman, but no one has money for anything else. So anyway, they asked that it be mandatory, that there be no judge's discretion on the imposition of the GPS as a condition of release, that it be in lieu of bond, that no bond allowed to be charged. Not sure about that. And then that it apply to all domestic violence cases. I had mentioned to the group last week about Memphis and the studies that we've done and through GA, and talking with the mayor, that it applied only to aggravated assault or attempted murder or domestic violence, and they were not in favor of that. They wanted every domestic assault case to be included, and I was a little surprised at that. Their opinion was if we can get the beginners, we may stop this from becoming an aggravated assault. I found that really interesting, but I've been gone so long, I wanted to make sure that I had the latest information, and to be candid, it was a little disturbing. This bill's more needed than I remember it being 10 years ago or 9 years ago, whatever it is. So, thank you so much. Ms. Madden, Representative Hardaway and I are probably going to wear you out, and we need to try and do this right. Now, Ms. Walsh and Patrick, Mr. Frog, I understand we want to build a perfect system, but if we do and the fiscal note says it's not going anywhere, then I've wasted a lot of time. So we may have to start walking before we run, if you see what I say. Any other questions or comments? Thank you so much. This has been enormously interesting to me, and I really appreciate all the time and effort that's gone into this, so thank you.
Thank you, sir. Thank you.
All right, next, House Bill 635, Senate Bill 600, Local Government Procurement and Online Bids and Offers. Let's see. Where's Mr. Okay. Oh, there he is. I was looking right at him. Mr. Shaver?
Thank you, Mr. Chairman, and good morning to everyone. I'll briefly provide an overview of the draft report and the draft recommendations for your review and comment. The draft is found behind tab 8 in your docket books. So this draft was prepared in response to a March 2019 motion passed by the House Local Government Committee requesting a study of House Bill 635 by Representative Travis, which would have amended a state law addressing the local government procurement process. So first, I'll quickly give you some background information, and then I'll present the draft recommendations. So current law provides that Tennessee's local governments may receive bids and other offers electronically or online. So House Bill 635 would have amended their current law to make it mandatory for local governments to accept online bids and other offers, and required that local governments provide a secure electronic interactive system to accept those electronic bids and other offers. The bill, which was promoted by a Louisiana company called Central Bidding that provides electronic procurement services to local governments, would have exempted some smaller local governments below population thresholds. If you look at Appendix A, there's a copy of the bill. So it's important to mention that while many of Tennessee's local governments use an online service to notify vendors of their purchasing opportunities to bid on, only a handful of Tennessee's larger local governments, such as Nashville, Memphis, and Knoxville, currently accept online bids through a secure online system, as the bill would have required. The local government purchasing officials we interviewed for this study, in general, are not opposed to the idea of receiving online bids, but they are opposed to the idea of making it a requirement. So local officials have said that receiving online bids can be beneficial for some local governments and for certain purchases, but not for all local governments or for all purchases for which they solicit bids and other offers. They express that they want to maintain their ability to decide if and when online bidding is best for them, as the current law allows. So the draft report before you explains that all Tennessee procurement stakeholders interviewed for the study were opposed to making it mandatory instead of optional for local governments to receive the online bids and other offers. So Tennessee's statewide association of local government procurement officials, known as TAP, provided a letter, which you can see in Appendix B, listing several reasons for opposing the bill, such as the potential cost to either the local governments or the vendors doing business with the local governments, and that they see the bill as an unfunded mandate. So if the requirements in the bill were to become law, the potential cost to local governments would vary. The cost would depend on whether the local government decides to use an online bidding company, such as Central Bidding, or contracts to build their own system. Some online bidding software companies charge local governments to receive online bids, while others, such as central bidding, offer their services for free to local governments but charge the vendors that submit the bids. Procurement officials have noted that the fees charged to the vendors are likely passed along to the local government. So other local governments may choose to contract to build their own secure online system. One local government official I spoke to from another state, for example, explained that they contracted with a third party to create and maintain an online system for around $3,000 a year that would meet the requirements of the bill. And staff reviewed other state laws, and we've identified only 2 states, Louisiana and Mississippi, that place similar requirements on their local governments. So now I'll turn to the draft recommendations in the report. So the first one says that while recognizing the potential benefits of receiving online bids and other offers, the Commission does not recommend making electronic procurement mandatory for Tennessee's local governments, as the bill would have required. The draft report also provides a second recommendation. The report explains that some states, such as Maryland and Virginia, have a state-level e-procurement system that they allow their local governments the option to use to receive online bids and other offers. Tennessee's state-level e-procurement system is operated through the state's Edison system. It would need to be upgraded to provide local governments the ability to use it to receive electronic bids. The state officials responsible for Edison estimate they would cost approximately $100,000 to update the Edison system so that local governments could have the option to use it to receive online bids. And the draft report recommends that if lawmakers want the state to have an e-procurement system that local governments could have the option to use to receive online bids and other offers, like Maryland and Virginia, they should consider upgrading the state's current Edison system. And I spoke with the president of the Tennessee Association of Public Purchasing, and she noted that they would support the second recommendation. So I'm happy to take any questions that you may have.
Questions? Mayor McDonald?
I just want to commend you all on this report. The one thing I kept hearing from other municipal mayors was, you know, this doesn't apply to me. You know, when you think about 345 municipalities across the state, and when you have a threshold of 8,000 or something like that, then you know, there's only, according to the 2010 census, there were only 12 cities, including Bartlett, that were above 50,000. And so when you start looking behind that number, it goes down real quick. And I think the average is 2,500 people in a city taking out the bigger cities. So, you know, a lot of people will say, well, this doesn't apply to me, so they're not worried about it. But I told them they need to worry about it because, you know, a couple things. One, it is my opinion that they maybe wouldn't be charging now, but if this bill went into effect, they might change their billing structure. And secondly, there may be a movement to try to reduce that threshold so that there are more cities involved in this at some point in the future. So I really love the permissive language as opposed to mandatory language if we do anything or if the legislature does anything with this bill at all. Thank you, Mr. Chairman.
Thank you, Mayor McDonald. Other questions or comments? Senator?
Thank you, Mr. Chairman. I appreciate this report and think it's well done. I'm curious whether there was any discussion around the secure aspect of this, because, I mean, ultimately a lot of solicitations, you know, like not every solicitation involves complex trade secrets. They're ultimately open records. I'm curious whether people had any opinions about that as a suggestion or.
There weren't any discussions around that aspect. The bill says a secure interactive online system, but it doesn't define what that is. So that is a good question, what that would entail if the bill were to pass.
Okay, thank you.
All right. Other questions or comments? I woke up this morning and turned on the news, don't know what channel, and a guy had hacked into a Ring camera and was talking to a 9-10-year-old girl. Just saying the most horrific things in the world to her. She was standing there terrified in her own bedroom. So when you say a secure online system, when one is created, I want a copy of it, but I don't think that's coming. Finally, my comments, I really appreciate this. I just don't know why in the world we would tell cities and counties how to do business. That's their business. We've got great leaders in both, and so I appreciate the draft report. Other questions or comments? All right. We'll have that back in January for a final decision. All right. Thank you, Mr.
Thanks, sir.
Shaver.
Minus Mr. Shaver.
Yeah,
It's been a pleasure to work with you
he's
all.
made it over the wall.
I bet you'll do a great job.
Yeah.
Thank you, sir.
Oh, that was
It's good.
that was so cute. It was over most of our heads. So you're going to need to dumb your jokes down just a little bit, Mayor. You're showing a little too much intelligence for me, anyway. All right, next, an interesting presentation. Mr. Carpenter, Tyler, and Jenny Camp are, oh, there you are. Come up if you don't mind. Senate Bill 1114, House Bill 1120, Community Resilience to Natural Catastrophes and Extreme Weather, an update. Thank you.
Thank you, Mr. Chairman and members of the Commission. Today, we are going to hear from Dr. Janie Camp. She's a member of the Three Sigma consulting team that the Commission has contracted with. The team has extensive experience researching resiliency issues to identify natural catastrophe and extreme weather risks, as well as the cost of action and inaction related to community resilience. Dr. Janie Camp is a research associate with the Department of Civil and Environmental Engineering at Vanderbilt University and associate director of Vanderbilt Engineering Center for Transportation and Operational Resiliency. And I want to thank Dr. Janie Camp for being with us, and I'll hand it over to her.
Ms. Camp, thank you.
Thank you, Chair and Mr. Carpenter. So this study, we've been asked by TACIR to assist them in a broader study of community resilience. We have a couple of tasks that are kind of under our purview. The first is kind of identifying different natural hazard risk across the state. Is there a reason?
We're working on it.
Okay. So the slides are coming. Our focus is only on extreme weather events and earthquakes. So focus primarily on the natural hazard aspects, not cybersecurity or different things like that for community resilience. And the second key objective for us is to estimate the potential cost of action versus inaction. And that is an extreme hazard and challenge in itself. But we've developed a methodology where we're looking at natural hazards across the state, looking at historic events and the occurrence of those events, how prevalent they are, the frequency, and also the impacts. There's national level databases on the events at the county level and also costs. Once they meet a certain threshold of $25,000 for an event, then they go into a National Oceanic and Atmospheric Administration database. So we have historic data that we can rely on as to the cost associated with prior events. We're also taking into account future event scenarios. So when we talk about resilience, we're thinking about disruptive events and how a community responds and recovers from those and is prepared to bounce back. So it's kind of an all-encompassing approach. So we're looking historically for baseline and then projecting to the future to the extent possible. For those future projections, I'll show you some examples in a minute, but we're taking into account kind of trend lines of increasing events, increasing severity, and also increasing population based on projections. And we're coupling the natural hazard side of assessing the hazard and the risk with the critical infrastructure assets. So we can't take into account everything under the scope and timeline that we have. So we're focusing on community level infrastructure assets. And I'll speak to those in a minute. And bringing those together using prior methodology that we've used in other studies to do an impact assessment. And from that, we're estimating cost of action and inaction. And inaction would be status quo, do nothing. We may see extreme events increase for some of these counties, different types of events, and also population increases means the consequences of events are going to be more significant. For the study, we have divided the state into 6 climate regions, and that's based on multiple other studies and looking at the literature and the data. We're trying to take into consideration the ecology across the state. There are ecoregions, that there's geologic divisions, there's governmental divisions. This is based on kind of the ecology and the topology and geology of the state. So these regions help us to say the climate might be similar in some of these areas for the future, and to help us in taking into account what risk may be foreseen. So when we look at the historic data, Tennessee is not immune to natural hazard events, and nearly every county has had some sort of natural hazard event that has shown up in those databases exceeding the threshold of $25,000 in damages. To the extent that one county has more events than another, it varies, and also what events. But everywhere across the state has hazards, natural hazards that they're exposed to, every county, every region. And if you look across the board, the average annual frequency is kind of the term that, and the common denominator we're using for all these, to put everything into similar terms. So thinking about how often an event would, on average, happen in a county. And if you look across the board, this does not account for earthquakes in this table that's presented. We're looking at 1,400 events from 1996 to 2018 on average across the state. And I feel like that's a lot when you start looking at the data. So no area is immune. And the primary events that we are seeing that seem to be having the most damage or showing up most frequently are straight winds, frozen precipitation. There's a lot of ways that these events are recorded. We've come up with this subset of categories that look at a lot of different weather events and hydrologic events. So when we talk about hydrologic events, that's typically flooding, which is the most common natural hazard in the world. When we start looking at the future and the projections, we are relying on some models that are commonly accepted, globally accepted, put together based on different scenarios for the future. And for those models, we can get information on heat and cold and precipitation, but not some of these other hazards. And so the hazards that are not heat, cold, or precipitation, we're using regression analysis. So essentially looking at the historic data and projecting it forward, assuming that a similar trend is going to continue. Using that analysis, we see that the extreme weather event frequency across the state is going to almost double by mid-century. And we're using a time frame of 2035 to 2055 to represent mid-century. And this is an average across that 20-year time period of the increase in events. For that time period, for the Southeast and specifically Tennessee, the projections are showing a significant increase in temperature. So we're going to have hotter summers and possibly milder winters. So those are things to consider when local municipalities are planning. So when we start looking at the projected increase in the number of days per year with maximum temperature at or above 95 degrees, and there's different thresholds, we went with 95 degrees because that's when you start seeing some of the impacts to human health. So you might need to start thinking about having cooling shelters and think about workers that are working outside for extended periods, and making a means to reduce their exposure and alleviate potential for heat stress. So you can see that West Tennessee is going to have a significant increase. If you think about our summers recently, and summer seems to be getting longer and extending further into what we normally considered fall. If you think about 40 to 49 days more a year of temperatures above 95 degrees, that's something to consider, and that's something to think about planning for cooling shelters and things like that, and worker safety. It also affects crops, and you can see more drought. Drought is interesting and it's complicated, but we're seeing a lot of the reports that we may have droughts interspersed with heavy precipitation. So we may see more days of average annual precipitation increasing, or thresholds for heavy precipitation increasing. The prior tables did not include earthquakes. They're their own beast to have to manage, but I'm not sure how many of you were aware about all the seismic activity in East Tennessee. We had a few somewhat significant but moderate earthquakes in East Tennessee in recent years. Since 1996, so we're using 1996 as kind of the first year for analysis of the historic data, because that's where you get more consistency across the different weather events. And it's some of the ways that data was collected for some of those weather events changed around that time. So to keep consistency across events and across years in the time frame, we started with 1996 for the weather events from the National Weather Service and NOAA database. So we're sticking with that on the earthquakes as well for comparative analysis. And since 1996 through 2019, we've had over 5,500 earthquakes in the state of Tennessee. That equates to, if you look at the average annual frequency, about 249 earthquakes per year in the state. And I'm not sure if that was a number that kind of surprised me. So I think a lot of focus has been on West Tennessee and the new Madrid zone, but we may also need to start thinking about East Tennessee and being prepared there. This just shows the estimated peak ground acceleration map for when you think about an earthquake. It's energy waves that are being released through the subsurface, and the topsoil is important there. That's why there's so much concern with the Memphis area and West Tennessee. But in East Tennessee, we have a lot of bedrock, but there is some concerns for bridges and things in that area. The map shown here is showing a 10% probability exceedance of earthquake happening in the next 50 years. So there's a lot of uncertainty related to earthquakes, but similar to the climate data, we're relying on scientists that study that more than us, and they're using best available models and a range of scenarios to come up with their analysis. Yes.
Senator? Yeah.
Sorry to interrupt. I understood like some of those words, I think.
Okay.
But
Sorry.
I'm highlighted on the fact that my parents are in red. So help me understand what red what this heat map means. Is this talking about just the fact that these are going to be areas that are subject to earthquakes, or do you get to a level where this is a risk of serious? That's what I'm trying to.
So I apologize. There's not a legend or scale here. So yes, red is worse. So for the red and the brown zone, your peak ground acceleration would be higher. So that takes into account the amount of energy that would be released under the various scenarios that they're running in the models through the subsurface, and also soil tops on the surface. So thinking about the peaks and amplitudes and frequency of those waves and the impacts that would have. So thinking about the peak ground acceleration that would occur, which then translates to building damages and those things. So aside from knowing that a specific building has been retrofitted or built to certain codes that account for earthquakes, these don't account for, the actual damages, but it's looking at, under the range of scenarios, what's the probability of having a significant earthquake happen and having damages or the waves propagate from that would result in damages. Does that help?
Yes.
Okay.
Oh, I'm sorry, Mayor McDonald?
In your slide before that one, it's kind of hard to distinguish the circles when it comes to the magnitude.
Right.
And so I guess that would be a question I would have. You kind of addressed it in what you just said in terms of, knowing the magnitude so that you'd actually see some damage, because
Right.
a lot of these, nobody felt it. If the seismic center hadn't said it happened, you didn't know about it.
Yeah.
And so I would, I guess, piggyback on what was said about that, just to help us understand. When you say, 50 years, we've been, in West Tennessee, we've been expecting Memphis to fall off in the river for years, and they're still there. So the other question is, are you working with the Seismic Center in Memphis?
So not directly, but I have worked with them in the past, and we're relying on data from the USGS at present. So this data came from USGS. We are working with the Seismic Center on other projects, so taking into account the knowledge gleaned from other collaborations with them to inform them. So on the magnitude, we've not had many above a 4, and I know the 4 doesn't mean much here, but around a magnitude of 5 is when you start really kind of seeing damages. But most of the earthquakes that we've experienced since 1996 are in the about 2.5 or less magnitudes, so only people in the immediate vicinity may feel a little shaking, but no real damage.
Right. Well, I would hope, we give them some money, so I'd hope you'd use their services
Okay.
to help us to understand that side, because obviously that's the most danger that we've got in the state. And with what happened with the old flood that created a real nice lake, we just,
Yes.
they've got a lot of good information.
Absolutely. This is, part of the scenarios are for a similar magnitude earthquake to what happened in New Madrid, or along New Madrid.
And just
back in
for
1800s.
example's sake, what was that magnitude?
That was estimated, granted it was in 1812 and 1811, so we weren't necessarily, we didn't have the seismographs and things to measure that, but based on accounts of damages that were in historical texts, the estimates by the scientists are that was around a 7.8 or above. And there were 3 quakes that happened between, I think, November of 1811 and January or February of 1812. So all of those were significant earthquakes.
Thank you. Thank you, Mr. Chairman.
You're welcome.
Okay. On the critical infrastructure side, we are looking at risk categories 3 and 4 according to the International Building Code. And these are critical infrastructure categories, which include mass gathering places, power generation, communication facilities, water and wastewater treatment plants, public health facilities, law enforcement, emergency response, and transportation facilities. And it's not every transportation, not every county road, but more of those significant interstates and critical transportation assets. In our study, we're looking at not the very localized county level, just because of the time frame and scope, but we are accounting for how many of these critical infrastructure assets are within a single county. And part of what we're working on is to come up with a county level kind of summary page of how many critical assets are in the county, what the historical level of natural hazard events have been, the count of that, and then also what exists for future projections for climate and potential impacts. Obviously, counties that have larger municipalities and urban areas have more critical infrastructure. So one thing we're considering and working on is kind of normalizing that based on population, things to put everyone on similar playing field. Getting to the cost of inaction, assuming that we do nothing, that no additional mitigation or funding is invested to reduce the hazards. So hazards are continuing along the similar trajectory of what we've been seeing historically at the county level and at the climate region level, coupled with increases in population. We're estimating that the average annual risk cost historically has been around, it's like $3 billion, I think. $3.3 billion. And then the average annual risk cost for the future. So taking that baseline and then looking to the future with the projected population increases and assuming that the events are going to follow a similar trend and to the extent possible taking into account global weather and climate data from models, we're seeing that increase almost double by mid-century. So this is, kind of a conservative estimate because we don't have a crystal ball and can't predict the future. So this is the best we can estimate based on available data. But still, that number is concerning. When we start looking at action versus inaction and investment in mitigation and resilience, and mitigation is a piece of resilience in helping either reduce the potential impacts of events. We can't necessarily stop some of these events from happening, but we can reduce the consequences and the impacts. So investing in mitigation activities which would lead to increased community resilience. The National Institute of Building Sciences has done a study on the financial impacts, and this is a nationwide study looking at different hazards across the nation, which is also broken down to state level estimates. They've done a lot of work. It's been quoted frequently on the riverine floods. So for flooding, they've estimated that $1 invested in mitigating flooding can lead to $6 in benefit, and that accounts for green space and different things dependent on the mitigation effort that's put in, whether it's gray infrastructure, hard infrastructure, or education and programs, policies, those things to help reduce the impacts. I do a lot of flood-related work, so that's the one that I'm most familiar with, but you can see, especially for thinking about West Tennessee, their estimate if you're following 2018 code requirements is that for $1 invested in earthquake mitigation, which would be putting dampers on buildings and retrofits and things like that to get everything up to code, you would see $12 in benefits. And it's part of that $12 in benefits for every $1 invested is reduced damages to your community, reduced emergency response costs and recovery costs and those things. There are kind of secondary benefits that are somewhat accounted for here, the indirect benefits that aren't easily accounted for, but there's also benefits for developers, property owners, lenders, tenants, and the community at large. The NIBS study focuses on, similar to us, we want tangible things that we can account for. So there's additional gains that aren't necessarily accounted for, like economic stimulus. So investing in mitigation may create jobs or create green space that the community can benefit from and things like that. So the key takeaways are that we have a lot of natural hazards to deal with. Nobody's immune. And the anticipated future is that the frequency and severity of those natural hazards will likely increase in the future. And then we couple that with increased population as we see growth, could lead to some significant costs to the communities and to the state to deal with natural hazards. The cost of inaction could lead to several $1 million of kind of damage costs and impacts to communities per year if you're looking across the state holistically. And then the investment in mitigation is ultimately a win-win, like a 3-to-1 or a 12-to-1 investment. Return on investment is always a good number. You don't see any negative return on investment for mitigation funding. And then ultimately, we think that investment in the mitigation resources could save not just in disaster costs, but human lives, and there's additional secondary benefits to that investment. And that's all I have. Thank you.
Thank you. Questions? Mayor McDonald.
Thank you. In talking about this in West Tennessee, particularly in Shelby County, when you talk about mitigation, you're talking about the building codes, and particularly when it comes to earthquake code, you know, there's been back and forth in the code of whether we should do the California regulation or deal with and recently it's dropped down some compared to where it was. And so the builders tend to talk about the idea that their responsibility is loss of life, not loss of property. And that if they build to the point that you can get everybody out, then you should insure the rest, and that would mitigate the problem. So I don't know whether you all have encountered that with the builders in your community, but that's what we often hear about, the additional cost of houses when you have to put up that extra panel now in the corners. So you have any thoughts on either of those 2 points?
So I guess first and foremost, I'm a licensed engineer, so my priority is human health and safety. So I'm going to lean towards human health and safety. While I understand building just good enough to ensure people can get out, I don't know that you have those guarantees under a more extreme earthquake event. I also, and this is my personal opinion, feel like education on safety and those things have value, and you could have people that have disabilities that have trouble getting out, or small children or elderly and stuff. So I don't know if that's necessarily being accounted for when they're building just good enough to get people out. But the broader impacts of, one, you want to focus on human health and safety and make sure people aren't harmed, but the amount of tax dollars that go into assistance for individuals, and just speaking from my experience in studying flooding, you know, that's a lot of money that if you invest on the front end just a little more, you save so much more on the back end. So I think a little bit of investment on the front end to help those buildings not fall, or not just stay long enough for people to get out, could reduce the debris generated that's going to landfills and has to be dealt with, and also have the secondary cost of inspection and retrofits and repairs and those things. There's all these ancillary costs that, you know, human health and safety is first, but there's a lot of costs to communities, and not everyone has the appropriate insurance to cover those costs. And we've seen that here in Nashville with the flooding we had in 2010.
Thank you. Thank you, Mr. Chairman.
Thank you. Other questions? Yes, sir.
Looking at your critical infrastructure page, could you
Yes.
help me with the water and wastewater treatment plants, or the, excuse me, the distribution and collection systems are not included in that?
We are not considering those at present. In all honesty, I'm involved in another project looking at water and wastewater systems, and unfortunately, there's not a good singular source that contains all that data and information, and some of the utilities don't even really have their systems mapped fully and appropriately. So we're focusing on kind of presence or absence of water and wastewater treatment plants in a community. The way we're dealing with it's not localized, is this wastewater treatment plant going to flood or not? We're essentially, we are bean counting in a way how many critical assets are in the community to help them kind of gauge what may be at risk and the potential cost and need for action.
Much broader than
It's
the
much
system
broader. It's
themselves.
not localized. You can do that localized study, but it involves a lot of data.
And one more question under transportation. Is that roads and bridges, or does that include rail and airport facilities?
We are including rail and airport facilities. We did a project for the state DOT, TDOT, a vulnerability assessment for them a few years ago. And on the airports, we're not including every tiny little helicopter pad as an airfield, but looking at thresholds that are accepted by the Federal Aviation Administration for criticality. So we're applying a similar methodology. We could account for every bridge and every helipad and everything, but the reality is when we think about resilience, we want to look at what is the most critical assets to help a community thrive and survive.
Thank you.
Other question, Mr. Clifton? All right. Anybody else? Mayor?
It's interesting, we spent a lot of time talking about information and broadband and allowing people to communicate on this committee, and one of the areas that, from my perception, we seem to be lacking in communication and information is how we inform people when we have a natural disaster, whether it be a tornado, whether it be a flash flood, whether it be a wildfire, as they had in Sevier County. Wouldn't taking advantage of advances in technology that we've discussed so thoroughly here, wouldn't part of infrastructure build looking forward being to take advantage of that technology so that we don't just build buildings so that they're safe, but that we enable people to have the information they need to act to enhance their safety?
So that's part of the reason communication is included here is the communication network is considered critical. Another piece of mitigation is also education and developing those systems for communication and ensuring that you have warning systems in place for the community. So I think that is a critical piece, public education and also this dissemination of warnings. But people need to know what those warnings mean. So that's an education piece that can go into mitigation. And there are mitigation aspects similar to public education and things like that that are kind of low-hanging fruit that require smaller investment than hard infrastructure but have a lot of gains.
All right, thank you.
Senator Yarborough, I think you had a question or a comment?
No, thank you, Mr. Chairman. And I wanted to ask, how do you kind of break down this data to the community and county level? So, I mean, like if you're in Sammy Arnold's hometown that's on the New Madrid Fault, you might care more about earthquakes. But if you lived through the flood here, I just assume that there are different ways of looking at, probably shouldn't be worth investment like in massive earthquake protection in the Middle Tennessee area that doesn't have that much. I mean, maybe it is in the longer, but if you're choosing between scarce resources, you have to make smart decisions.
Yes.
How do you figure out where we're going to actually, potentially save money on, I think, how do we save, because I think the purpose is if we're going to be investing in infrastructure so that we save money in the future, we need to make sure that we're actually doing that and not just, building things that people want to build.
Absolutely. So I am by training an engineer, and I'm the first engineer that will probably say we can't build out of every hazard. And there are places that infrastructure is really not going to help. And I cringe when I see communities building subdivisions in the bend of a river, because there's a reason people haven't lived there for many generations. And just because we think it's a pretty area doesn't mean we need to build there. Investing in infrastructure is one mitigation option. There are multiple ways, like education, improved communication, and warning systems. As for prioritization, that is a challenge. And I pulled this slide back up because you can identify what your hazard is as your primary concern. And that's going to have to happen on a very localized level, at a county level. And that's somewhat beyond the scope of the study. It's definitely something we're interested in doing and working on and contributing to. But it's a very localized level, and you have to do kind of an analysis and a study to identify what mitigation options make sense for your community. And there are risk thresholds. I mean, obviously, we would love to, I'm a parent, I would love to put my kids in bubble wrap every day and make sure they don't get hurt, but that's not realistic or feasible or cost effective. And they have to grow. So we do grow and learn from some hazards and experience of the smaller hazards that aren't as detrimental. I do think that going to the National Institute of Building Sciences study, there are examples for each of these hazards listed here of mitigation options that feed into this return on investment. And I think there are options for, there's a lot of literature out there that can be relied upon. When it comes to working with an individual community, they can work with consultants and engineering firms and rely on things like the report that's being generated in this NIBS study to help them kind of evaluate what are the best mitigation options that they have the funds to invest in that will reduce their risk and vulnerabilities to help them be more resilient. But they can't I don't think any of us can outbuild every natural hazard that we foresee. So it's not feasible or, it's not effective. So we have to, it takes kind of that localized evaluation of what are our key hazards. And some of the maps like this says, for Davidson County, maybe we're not going to see that much more precipitation. So maybe, investing in protection for a 500-year flood event may be enough to help us kind of withstand the big events in the next 30 years. But perhaps, if you're West Tennessee, your priority is earthquakes, and maybe you've invested a lot in earthquakes, and then you realize that heat's going to be a problem in the future, and maybe there's some low-hanging fruit related to heat to just help your citizens withstand that as you move forward. I know that was a bit of a rambling answer, but...
It's very helpful.
Okay.
All right, thank you, Ms. Camp. Other questions or comments? Mayor Anderson.
Thank you. Seeing what I see on television and being around during 2010 in our county and not being addressed here, what about the potable drinking water? I see no reference to that into the report, and yet when we have disasters all over the news portrays them getting water to people. How do you handle, and being an ex-military, I kind of think water and food are as important as structures.
Absolutely. So we're not specifically looking at potable drinking water and access and availability of redundant supplies for that. That's kind of beyond the natural hazard scope of this and the approach and the timeline that we have. I'm a water person, so I totally agree with you that access to water and food, but that's also where knowing if you have water treatment plants in your community, how many of those you have that might be at risk in a natural hazard can help inform that decision. Then also thinking about what other resources may be available. So I think part of mitigation and response planning should be to identify alternate sources for drinking water. And I know, in 2010 here, 100 was underwater, so we were under a water restriction during a flood event, which seems ironic. But having additional supplies, ensuring you have wastewater treatment plants if you're in an earthquake zone, or tanks. So having storage tanks for water, most of the plants that I'm familiar with treat a surplus and there's storage in those tanks that can withstand some fluctuations when you do have issues. And water treatment plants go down for filter cleaning and things like that, and we don't even notice it when they're doing maintenance and things like that, because they do have additional storage. But ensuring that those tanks are safe and you have power, redundant power sources to keep the pumps running and those things, I think that's more of the concern when we're looking at natural hazards and resilience and meeting the needs of the citizens.
And as a follow-up, I might just remind you that in Tennessee, and I being one of them, we still are on well water, and our backup water source is not always real good during those times. So, and I think a lot of people in our state are not privy to living in our cities.
Yes. Unfortunately, we are a water-rich state, and we take water for granted. And as we look to the future and potentially see more droughts, that is something we do need to think about, is our water sources. We've seen our neighboring state, Georgia, vying for some of our water resources in recent years, and I think we need to heed that as a warning and also think about what we would do in similar situations.
All right, other questions or comments? All right, just so that the committee will know, it's outside the scope of the work that you've done, very able work, Ms. Camp, and thank you for that.
Thank you.
I'm looking on the list of the things that critical infrastructure, water and wastewater treatment, I assume that you and I, Mayor Anderson, think about the same thing. I think our report should include, I'm sure that Senator Watson will come up with whatever money is necessary to meet all these potential. That won't be a problem. I'll just mention it to him on the way out. That should take care of that. But all jokes aside, how do we prepare the average family for a loss of potable water, or maybe for 7 or 8 days? Senator Watson and I, a couple of months ago, I guess, we went through, we had a water main break that turned off water to Erlanger Hospital and to many homes. Having represented the jail for 20 years, my first thought was, how do we air condition that building? We do it with water. It got to, I think, about 103 degrees in that building very quickly. How do they use the restroom? How do they take showers? So it was really a greater emergency in my mind, perhaps, than it was in others, but it rippled across our community very quickly. So I'm interested that our report include, for those times or those events that we cannot plan for, how does the average citizen maintain a safe environment for their family for some appropriate period of time? And I don't know if that's 3 days, 7 days, 12 days. I have no idea, but could we, Cliff, see that gets included in the report and address Mayor Waters' concerns about food and potable water?
Yeah, absolutely, Mr. Chairman. And I just want to clarify, while that kind of thing is outside of what we've asked 3 Sigma to do for the contract, we're using the data they're preparing for us on the risks and the value of mitigation to kind of help inform the rest of the report. So the rest of the report is going beyond that, and our goal is to include kind of processes and examples, best practice examples of mitigation that can be used by the state and local communities to do just that kind of planning and preparation.
And for the average family that
And the
wants
average-
to make sure that they're prepared for some period of, during 2011, we had tornadoes come through my community. 11 people were killed. We didn't lose water, wastewater. We didn't lose any of those things. But let me tell you, as heading up that effort to feed and house people and to treat them and to do all those, when my cell phone would not work out there, we literally had a lady that drove back and forth constantly to cell service to call. And then the sheriff's department brought out a mobile command team and communication was an enormous problem. I had no idea how we rely on the internet and communication now for everything. We had people, when we ran out of water, we would call Coca-Cola and Budweiser, and they would deliver enormous amounts of water for people to have. But if we couldn't call them and tell them, we had to have someone drive to Saudi Daisy to do that. So it was quite an interesting time. I learned a lot in a short period of time. Other questions or comments from Ms. Camp? Yes, Mr. Cliff.
Mayor Anderson's comment and concern was the basis for my question. If we can't get the water and wastewater to and from the plants to the communities, then we're not able to serve them. That was the basis for my question.
Thank you.
Well, it's an interesting topic, and I know all of our mayors, county and city, are extremely interested in taking care of people if something happens. I've seen it, and so let's make sure that that's included. So we have at least some standard there until Mayor Bickers can get to that house. They're going to be okay with his group. All right? Well, thank you so much, Ms. Cam. It's very interesting.
Thank you.
Any other questions or comments? All right, thank you.
Thank you.
Well, we're down to any other business. Anyone have any matters you want to bring before the committee before we go? Our next meeting is January 16 and 17. Anything else to come before the body? Anyone have any questions or comments? All right.
Just,
Mayor McDonald.
You guys will be going into your session on the 14th.
I think the 14th.
Busy week.
Yeah, it's going to be a busy week. Going to be a busy week. All right. Any other questions or comments? On behalf of the council, for those of you who are here, we wish you the warmest season's greetings, and to all the members here. We'll see you back in the new year, and we'll solve some problems. So, thank you very much. We're adjourned.